An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Dobbs v. Jackson Women's Health Organization, 2022. Roe v. Wade, 1973, recognized a constitutional right to abortion. In the wake of Roe, a nationwide political and social movement emerged with the goal of overruling that controversial decision. 2 decades later, in Planned Parenthood v. Casey, 1992, the Supreme Court was asked to reverse Roe. However, the court declined that step. The controlling opinion eliminated the trimester framework, but upheld Roe's, quote, central holding. Under this standard, the government could not impose a substantial burden on access to abortion after the point of viability. Over the next 3 decades, the movement to overrule Roe would continue to grow. A pivotal point came in February 2016. Justice Scalia suddenly passed away. President Obama nominated Judge Merrick Garland to fill the vacancy. Senate Republicans, however, declined to hold a hearing, let alone a vote, on the nomination. Shortly after his inauguration, President Trump nominated Neil Gorsuch to fill Scalia's seat. Gorsuch was confirmed in April 2017. 1 year later, Justice Kennedy, the last remaining member of the Casey plurality, announced his retirement. President Trump nominated Judge Brett Kavanaugh, who had clerked for Justice Kennedy, to fill the vacancy. He was confirmed in October 2018. Then, in September 2020, Justice Ginsburg suddenly passed away. President Trump nominated Judge Amy Coney Barrett, who had clerked for Justice Scalia, to fill the vacancy. She was quickly confirmed prior to the presidential election. These 3 confirmations established the most conservative Supreme Court since the 1930s. In May 2021, the Supreme Court granted review in Dobbs v. Jackson Women's Health Organization. Let's start with the facts of Dobbs. In 2018, Mississippi enacted a law that prohibited abortion after the 15th week of pregnancy, quote, except in a medical emergency or in the case of a severe fetal abnormality. The law defined medical emergency in 2 ways. First, an abortion can be performed where, quote, it is necessary to preserve the life of a pregnant woman whose life is endangered. Second, an abortion can be performed, quote, when the continuation of the pregnancy will create a serious risk of substantial and irreversible impairment of a major bodily function. 15 weeks is several weeks before the fetus can be viable outside the womb. This rule conflicted with the viability line drawn in Casey. The Jackson Women's Health Organization, an abortion clinic in Mississippi, challenged the constitutionality of the law. The lower courts held that Mississippi's law imposed a substantial burden on access to abortion prior to the viability line. A study guide. Why would Mississippi enact a law that clearly violated Supreme Court precedent? Mississippi appealed the case to the Supreme Court. During oral argument, Scott Stewart, the Mississippi Solicitor General, said the
court should overrule Roe and Casey and uphold the state's law.
6 members of the court voted to uphold the Mississippi law. Justice Alito wrote the majority opinion, which was joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. The court held, quote, that Roe and Casey must be overruled. Chief Justice Roberts wrote an opinion concurring only in the judgment. He would have upheld the 15-week ban by rejecting the viability line, but Roberts would not have overruled Roe and Casey in their entirety. Justices Breyer, Sotomayor, and Kagan wrote a joint dissent. Study guide. In May 2022, about 2 months before Dobbs was decided, Politico published a leaked version of Justice Alito's draft majority opinion. This draft provided the public with a preview of the ruling. How might the leak affect Supreme Court deliberations in the future? The majority opinion addressed 4 primary issues. First, the court held that the Constitution does not confer a right to abortion. Justice Alito wrote that, quote, "The Constitution makes no reference to abortion at all." He acknowledged that some constitutional rights are not enumerated or mentioned in the text. Under Washington v. Glucksberg, 1997, the courts can protect unenumerated constitutional rights that are, quote, "deeply rooted in this nation's history and tradition and are, quote, implicit in the concept of ordered liberty." But a right to abortion, Alito wrote, quote, "does not fall within this category." The court observed that, quote, "such a right was entirely unknown in American law until the 1960s." And, quote, "when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy." Alito reached an inescapable conclusion that, quote, "a right to abortion is not deeply rooted in the nation's history and traditions." The joint dissent agreed that in 1868, there was no nationwide right to end a pregnancy, and no one thought that the 14th Amendment provided one. But the dissenters rejected this originalist approach to judging. In their view, quote, "the Constitution does not freeze for all time the original view of what those rights guarantee or how they apply." The court, according to the dissenters, should keep, quote, "true to the framers' principles by applying them in new ways, responsive to new societal understandings and conditions." Reading the Constitution through a 19th century lens, they wrote, would, quote, "consign women to second-class citizenship." The dissent claimed that when the 14th Amendment was ratified, women were not part of, quote, "the people." And male ratifiers, quote, "were not perfectly attuned to the importance of reproductive rights for women's liberty." Study guide. In 1868, women could not vote. Did this fact mean that women were not part of, quote, "the people," protected by the 14th Amendment in 1868? Can all Americans vote today? Does the 14th Amendment protect Americans who cannot vote? Rather, the dissenters would interpret the 14th Amendment in light of recent Supreme Court decisions. The meaning of the Constitution, they wrote, quote, "gains content from the long sweep of our history and from successive judicial precedents." These cases, quote, "apply the Constitution's most fundamental commitments to new conditions." The dissenters pointed to Lawrence v. Texas, 2003, which recognized a constitutional right to engage in same-sex relations, and Obergefell v. Hodges, 2015, which recognized a constitutional right to same-sex marriage. Decisions like Obergefell and Lawrence broadly construed, quote, "the majestic but open-ended words of the 14th Amendment, the guarantees of liberty and equality for all." And those cases were not constrained by a 19th century conception of liberty. In this fashion, Roe and Casey are, quote, "embedded in core constitutional concepts of individual freedom and of the equal rights of citizens to decide on the shape of their lives." Study guide. How did the majority distinguish Obergefell and Lawrence from Roe and Casey? The second element of Dobbs turned to stare decisis, the principle that the court should stand by its own precedents. Justice Alito acknowledged that some of the court's, quote, "most important constitutional decisions have overruled prior precedents." Brown v. Board of Education, 1954, repudiated the separate but equal doctrine from Plessy v. Ferguson, 1896. West Virginia Board of Education v. Barnett, 1943, overruled Minersville School District v. Gobitis, 1940, and held that public school students could not be compelled to salute the flag in violation of their sincere beliefs. West Coast Hotel v. Parrish, 1937, overruled Atkins v. Children's Hospital of D.C., 1923. This precedent, quote, signaled the demise of an entire line of important precedents concerning the right to contract, including Lochner v. New York, 1905. More recently, Obergefell overruled Baker v. Nelson, 1971, and Lawrence overruled Bowers v. Hardwick, 1986. There are many other similar cases. The majority identified, quote, 5 factors that weigh strongly in favor of overruling Roe and Casey. First, the nature of their error. Second, the quality of their reasoning. Third, the workability of the rules they imposed on the country. Fourth, their disruptive effect on other areas of the law. And fifth, the absence of concrete reliance. Study guide. How do these 5 factors differ from the, quote, prudential and pragmatic considerations of stare decisis that the Casey plurality identified? First, Justice Alito wrote that Roe was, quote, egregiously wrong and was, quote, deeply damaging. The decision, quote, short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. Like in West Coast Hotel, Alito wrote, the court should, quote, overrule decisions that wrongly removed an issue from the people and the democratic process. Second, Roe was not based on, quote, text history or precedent, but, quote, relied on an erroneous historical narrative about laws prior to the ratification of the 14th Amendment. Roe observed that certain abortions performed early in the pregnancy may not have been considered homicides. However, Alito wrote, the failure to criminalize certain abortions does not mean, quote, that abortion was permissible, much less that abortion was a legal right. Indeed, Casey, quote, refrained from endorsing most of Roe's reasoning. Third, the lower courts have struggled to apply Casey's undue burden test. Different courts have reached different conclusions about similar abortion laws. Justice Alito wrote that, quote, continued adherence to that standard would undermine, not advance, the even-handed, predictable, and consistent development of legal principles. Fourth, Roe and Casey have distorted many other areas of the law, including federal court jurisdiction and the freedom of speech. Fifth, the court turned to reliance interests. In Casey, the plurality, quote, perceived a more intangible form of reliance. Specifically, Casey observed that people had, quote, organized intimate relationships in reliance on the availability of abortion. Moreover, the ability of women to, quote, control their reproductive lives has allowed them to, quote, participate equally in the economic and social life of the nation. During oral argument, Justice Kagan articulated this concern. Since Roe, she said, there have been
50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country.
This history, Kagan observed,
places us in an entirely different situation than if you had come in 50 years ago and made the same arguments.
Dobbs rejected this understanding of reliance interest. The courts, Justice Alito wrote, usually, quote, emphasize very concrete reliance interests like those at issue in property or contracts cases. But the courts are, quote, ill-equipped to assess generalized assertions about the national psyche. Study guide. Everyone agrees that lower courts can never overrule a Supreme Court precedent, but the Supreme Court can overrule its own precedents. But there's broad disagreement over when the court may do so. In Dobbs, who struck the right balance? The majority or the dissent? The third element of the case focused on the Supreme Court's, quote, legitimacy. The Casey plurality worried about the cost of reversing Roe.
To overrule in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question.
there was a sustained political movement to reverse Roe. During oral argument, Justice Breyer worried that
with the super case like this, the rare case, the watershed case,
that people will
say, no, you're just political. You're just politicians.
He warned that such politicization will
kills us as an American institution.
Justice Sotomayor stated the issue more bluntly. Sotomayor remarked that sponsors of the Mississippi law supported it
because we have new justices on the Supreme Court.
Sotomayor asked,
will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
She added,
if people actually believe that it's all political, how will we survive?
The Dobbs majority rejected this conception of legitimacy. Justice Alito contended that, quote, Casey broke new ground when it treated the national controversy provoked by Roe as a ground for refusing to reconsider that decision. The Casey plurality's understanding of legitimacy, Alito suggested, quote, went beyond this court's role in our constitutional system. Stare decisis should not be, quote, subject to the vagaries of public opinion. The court, quote, cannot allow its decisions to be affected by any extraneous influences such as concern about the public's reaction to its work. The fourth and final element of the case settled the appropriate standard of review. The court determined that abortion restrictions should be reviewed with rational basis scrutiny. Abortion was not a fundamental right. Regulations of this non-fundamental right, quote, must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. Here, the majority relied on the highly deferential standard of review from Williamson v. Leoptical, 1955. Mississippi's 15-week abortion ban was justified by the state's legitimate interest in, quote, protecting the life of the unborn. Under this test, Mississippi's 15-week ban easily passed constitutional muster. Justice Thomas wrote a solo concurring opinion. Thomas restated his long-standing view that the Due Process Clause, quote, at most guarantees process. The Due Process Clause, he wrote, does not, quote, forbid the government from infringing certain fundamental liberty interests at all, no matter what process is provided. Thomas rejected the entire doctrine of substantive due process. In a future case, Thomas urged, the court should, quote, reconsider all substantive due process precedents, including Lawrence and Obergefell, as well as Griswold versus Connecticut, 1965, which recognized a constitutional right to contraception. During oral argument, Justice Sotomayor told the Mississippi Solicitor General,
all of those other cases, Griswold, Lawrence, Obergefell, they all relied on substantive due process.
Sotomayor asked,
you're saying there's no substantive due process in the Constitution, so they're just as wrong according to your theater.
The majority insisted that these other precedents were not at risk. Roe and Casey were, quote, fundamentally different from other substantive due process cases because an abortion, quote, destroys fetal life. Obergefell, Lawrence, and related cases did not, quote, involve the critical moral question posed by abortion. Justice Alito stressed that, quote, nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. And, the court added, each of these cases would be, quote, subject to its own stare decisis analysis. The reliance interest and workability of Griswold, Lawrence, and Obergefell are, quote, different than those of Roe and Casey. Study guide. Are Griswold, Lawrence, and Obergefell in doubt? Is abortion really different? Can the majority's assurance be trusted? Justice Kavanaugh wrote a solo concurring opinion. He suggested that states cannot bar their residents from traveling to another state to obtain an abortion. And Kavanaugh suggested that a state cannot, quote, retroactively impose liability or punishment for an abortion that occurred before Dobbs. Chief Justice Roberts wrote an opinion concurring in the judgment. He agreed with the majority that the 15-week ban was constitutional. But he would not have overruled Roe and Casey in their entirety. Rather, he would have, quote, discarded the viability line, quote, under a straightforward stare decisis analysis. Indeed, during oral argument, Roberts asked if
viability at issue in Casey.
Julie Rickleman, the lawyer for the clinic, explained that
the viability line is the central holding of those cases. Casey mentioned it no fewer than 19 times.
Still, Roberts' concurrence proposed a saving construction of the precedent. He reconceived Roe. The right to terminate a pregnancy should, quote, extend far enough to ensure a reasonable opportunity to choose without regard to viability. Most women discover their pregnancy around 6 weeks of gestation. Roberts thought that the 15-week mark is, quote, well beyond the point at which it is considered late to discover a pregnancy. However, Roberts would not jettison Roe and Casey altogether. He warned that the, quote, dramatic and consequential ruling was unnecessary and would cause a, quote, serious jolt to the legal system. The majority responded that the Chief Justice does not, quote, offer any principled basis for his approach. Moreover, the viability rule was a, quote, critical component of Roe and Casey. Justice Alito wrote that discarding the viability rule, quote, cannot be defended on stare decisis ground. Crucially, the Chief Justice was unable to attract another vote for his position. Had he done so, Justice Alito's opinion would have become a plurality opinion that could not overrule Roe and Casey. In the end, the court overruled Roe and Casey and, quote, returned that authority to the people and their elected representatives. The majority concluded, quote, we do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. Neither do we. In our view, there are three primary areas of uncertainty. First, how will Congress and state legislatures now deal with the abortion issue? Second, what constitutional issues will arise around any future state or federal legislation? And third, how will the majority's reasoning of Dobbs affect the status of other, now recognized constitutional rights?